Hi, my name is Jeff Pfeiffer. I'm an attorney at the Lopez Law Group. I handle a lot of the personal injury cases that we get that come through the door. This is our personal injury podcast where we try to answer a lot of questions that clients have when they come through the door. One of those that I typically get during the initial consultation is, what do I have to prove in my personal injury case? What are the elements of my cause of action? What do I have to be able to show in order to recover in my case? And the answer to that is you have to be able to show negligence. And there are elements that you need to be able to prove with regard to a negligence claim. In its simplest form, it's you need to be able to show that somebody else is responsible for your injuries. From a legal perspective, that boils down to three things. You have duty, causation, and damages. Duty, I'd like to put it in an example, is just a car accident case. Everybody who gets behind the wheel and gets on the road has a duty to every other driver behind the wheel that's driving with them on the interstate. They have a duty to keep their car in their own lane, avoid their car making contact with somebody else's vehicle. And if they do make contact with somebody else's vehicle, or if they are negligent in the operation of that vehicle, that is a violation of their duty. If they were to hit you and you were involved in an auto accident, by them making contact with your vehicle, that's a violation of the duty that they owe to you as another motorist on the road. The next element that we have to be able to prove is causation. So it's not enough just to show that somebody made contact with your vehicle. We have to be able to show also that by making contact with you and breaching that duty, the breach of that duty caused your damages, resulted in you being injured for the accident. If we're able to show that because somebody hit your vehicle, that's the reason that your injuries occurred, then we've satisfied that second element. That is known as causation. And then the final element that we have to prove is damages. So I have to be able to show, and any personal injury attorney has to be able to show that as a result of the breach of that duty that caused your injuries, that you've suffered some sort of legally compensable damages, whether it is a strain and a sprain, whether it's ultimately a bulging disc in your back, a herniated disc in your neck, broken bones, lacerations, anything that a doctor can say is related to the accident when that other vehicle made contact with your vehicle. Those are legally compensable damages. If we're able to show all three of those things, duty, causation, and damages, then you've met all the elements that are required to bring a negligence action. Now, obviously, the person that you're going after in a case probably is going to disagree with that. They're not just going to openly admit that they were negligent. They're not going to openly admit that they breached a duty. They're not going to admit that, and the big one is they're not going to admit that your damages and your injuries were caused by that accident. You will find more often than not, especially in personal injury cases that are in litigation, you will see that defense attorneys who often represent insurance companies, their number one goal most of the time is to show that you can't meet the causation argument, meaning that there's maybe something else in your history. If you were involved in another auto accident 10 years ago, they're going to say that that's the cause of your injuries. That's the cause of the pain that you're suffering now. It's not from the auto accident that you were just involved in a couple of months ago, and therefore they try to make it look as though the causation element hasn't been met, so that they don't have to pay out any sort of money to you for your damages. That is one very common way that defense attorneys and insurance companies try to prove that you have not met all three elements. So at the end of the day, if you're able to show those things, duty, causation, and damages, if you can show that the at-fault driver breached that duty by making causing a collision with the vehicle that you were driving in, and ultimately there's causation there. If you can show that accident's the reason that you're suffering from the pain that you're suffering in now, that satisfies the second element, and then the third element is damages. And ultimately, that is proven by going to a physician, getting a physician to look at you and say that ultimately what you're suffering from was caused by that accident. So if you've got duty, breach, you've got duty, causation, and damages. If you have all three of those and you're able to prove those, then you've satisfied all three elements that's required for a negligence claim, and you're able to move forward with that action. Not to say that a defense attorney and an insurance company isn't going to try to say that you haven't met all three of those elements. That is very common, but at least we have enough to argue that you have satisfied the three elements that you have to satisfy. So if you feel like you've maybe met all three of those elements, if you have somebody who's been involved in an auto accident, whether it's yourself or somebody that you know, and it's due to no fault of your own. Maybe it was another car that struck the vehicle that you were riding in. Maybe you slipped and fell on somebody's property because of some negligence. If you're dealing with a situation like that and you're looking for legal help, you can give us a call here at the Lopez Law Group. Our phone number is 727-933-0015. And we're here, typically we answer 24/7. We're here from 8:30 to 5:30, Monday through Friday. So we're always here. If you get into an accident and you need assistance, just give us a call.